Welcome to this episode of Reasoned Discourse with Jules Mermelstein. I'm Jules Mermelstein, your host. On Reasoned Discourse, we will discuss public issues in a civil way to attempt to see if there are points all sides can agree on. Today's episode is on a criminal justice issue, the felony murder doctrine. Briefly, the felony murder doctrine is a legal principle that if you are a participant, even a minor participant, in a felony, and someone dies during the commission of the felony, then you are guilty of murder. In Pennsylvania, for most felonies, that means second-degree murder, and the sentence is life in prison without possibility of parole. We are honored to have two Pennsylvania legislators with us in the studio today. Senator Daylin Leach, who has submitted a bill to eliminate the felony murder doctrine in Pennsylvania, is here. Welcome to our studio, Senator Leach.
Good to be with you.
And also in our studio is Representative Todd Stevens, a former prosecutor who is against eliminating the felony murder doctrine. Welcome to our studio.
Thanks for having me.
So we'll get right to it. And Senator Leach, why are you opposed to the felony murder doctrine?
Well, let's go back in history a little bit. In the 1600s in England, they didn't really have prisons. They had jails to hold you until you were hung. You were essentially hung for any crime. They used to hang pickpockets and thieves and things like that, as well as murderers. Over time, we got away from that theory of punishment. We started realizing there should be some correlation between blameworthiness and punishment. The more serious thing you do, the more you should be punished, and the less serious thing you do, the less you should be punished. Felony murder doctrine turns that on its head. It eliminates that concept. It says essentially, if you were involved in a felony of any kind, and even as an accomplice, and even in the most sort of distant way, and as you say, someone there's a homicide as a result, you are as guilty as the person who committed the homicide. So let me give you just a quick example. Let's say you say to me, there's a guy in my neighborhood who's got great stereo speakers. I'm going to go steal his stereo speakers. Can I borrow your car? I'm like, okay, here's my car. You then go and for some reason, let's say the police come, okay, and they try to shoot you and they shoot someone else or whatever it is, someone dies. I'm just still sitting in my room. I never intended to kill anyone. I've never told there was a gun involved. In fact, the person I lent my car to didn't have a gun. I never intended or wanted anyone to get killed. I could be put in jail for life for that. And I can give you many other bad examples. We may not have time to, but maybe as we discuss it. That's just unfair, it's immoral, and it costs you about $44,000 a year to keep these people in jail. There's about 400 people in Pennsylvania who are in jail for murder who never murdered anybody. There have been 80 people nationwide sentenced to death who never killed anybody. And in fact, sometimes the person who does kill someone is punished less than the person who had nothing to do with the killing. This is an anachronistic remnant of sort of draconian penal codes from centuries ago. Every other Western democracy has eliminated this doctrine. Many states have, and many more have modified it. It's time Pennsylvania do the same.
Okay, thank you. And Representative Stevens, why are you opposed to eliminating it?
Well, for a couple different reasons. And, I guess first and foremost is really the concept of, we really need to take a look at the concept of a team. I know that Senator Leach has a team that assists him on his daily duties as a senator and through his campaign, as do I through my campaign, and also as my duties as a legislator. And the fact is, you always hear the old adage, a chain is only as strong as its weakest link. So, everybody plays a role. And when you have a team of individuals, more than one, who are committing violent crimes, these are not, and I think it's important to bear out the example that Senator Leach gave. There are a couple facts that are necessary in order for that scenario to be true. And, the first one is that it was going to be a robbery. Now, a robbery is taking something from someone by force or threat of force. So we're not talking about, the speakers were in his car and he's nowhere to be found, so I'm going to break into his car and steal the speakers. This is, I'm going to forcibly take something from him. That's what the definition of robbery is. And so, in my mind, whether you're serving as a lookout or you are providing assistance by providing the getaway vehicle, or whether you are helping in the planning, or whether you are helping in the distribution of the property or the sale of the property thereafter, and this was all planned up front, and you have an active role in this whole thing in any of those capacities, then to me, look, if you're in, then you're in. If you're going to share in the proceeds, then you should share in the penalty. And so, everyone plays a role in a lot of different initiatives, and we acknowledge that on teams there are folks who play different roles and serve in different capacities. But if any one of them should fail, then very often the entire end game fails. And so for that reason, while you might view them as a minor participant, in the end, they very well could have been the linchpin that kept that team together. Moreover, one of the last cases I prosecuted in the Montgomery County DA's office was a home invasion robbery where it was meticulously planned. There were about, I think, 7 people involved, and this was the family's nephew who detailed for the perpetrators why they should go rob this family, because they kept large sums of money in the home allegedly, and detailed where he thought they would find it, what their daily routine was, provided them directions to the location. There were other folks who provided transportation to and from. There were other folks who provided a safe house for everyone to return to with all the stolen property. And when these guys went into this building, into this home early in the morning, they went in there to forcibly steal this property, and in the course of doing so, killed somebody. And as a result, we had sort of the classic felony murder scenario. And if you saw the pictures of that victim laying in that garage, in the way that he was brutally murdered in front of his wife and kids, it's hard to not say, guess what? Everyone who participated in that entire event should be held accountable for what transpired in that home. And
Well, I have a question about one of the things you said. You were talking about a robbery. Isn't burglary also one of the felonies that can rise?
it is, but only under certain circumstances of burglary. I believe it's when a person's present, because you can burglarize a business, for instance, when no one's there, and you can burglarize a home when no one's there, but I'm pretty sure it requires that someone be present in the home for the burglary. That's part of a felony.
You don't have to prove that you knew someone was going to be present, was going to be home. You could have thought, as you said, I'm going to rob the guy's stereo speakers, no one's going to be there. And in fact, no one was there. The police come, and suddenly they shoot someone, and the person who's not there at all is going to be charged. There's some famous cases of this. There was a woman who was a victim of domestic violence. She wanted to get her stuff out of her ex-boyfriend's house. He wouldn't let her. She had a friend of hers drive her to the house. All of a sudden, the guy starts taking some stuff for himself. He's like, well, since I did this, I'm going to take stuff for myself. So it was a burglary. She was part of it because she brought him to the house. Anyway, again, the cops come, and there's an altercation, and he winds up shooting a cop. She didn't know he had a gun. She is spending the rest of her life in prison. And well, actually, she's not, because it was overturned on appeal, but she spent many years in prison. It was a case made famous by Hunter Thompson, but there's many cases like this. And sure, when you look at a victim, a picture of a victim, that's tragic. But when you look at a picture of a 17 or an 18-year-old kid who's now 35, who's been sitting in a small prison cell for years for something he never intended to do and never did, and keep in mind, the prosecutor not only doesn't have to prove intent, and they don't have to prove an act in furtherance of killing someone. They don't even have to prove it was foreseeable. It could be some bizarre set of circumstances that you never knew. There was a case in another state where a guy wanted to sell some marijuana. It was a felony. He wanted to sell the amount. He wanted to sell some marijuana. The guy was coming over to buy marijuana. The security guard would not let the guy in the dorm. So they got in a fight, killed the guy. Suddenly the cops come up, you're under arrest for murder. Like, where is the justice in that? Now, there's a team, I agree with Todd, there's a team, but we're smart enough to discern who was the quarterback and who was the guy filling the water pitchers, and who was the guy who was just a fan. I mean, we can draw that out. The guy who killed the person or the people who killed the people, they should absolutely be punished. If you can show that I knew that was going to happen or intended for it to happen, even if I wasn't there, I should be punished. But if I had nothing more than just like, hey, we're going to steal some speakers, lend me your GPS so I can get to the house, I'm not a murderer, and I shouldn't be punished as a murderer. We have way too many people in jail, and this is one of the reasons why.
Just to be clear, so I don't want to leave a misimpression.
Okay.
I don't believe that delivery of drugs in Pennsylvania is going to subject you to felony murder rule. It's limited to very certain rape, robbery, involuntary deviant sexual intercourse, arson. It's violent crimes that, by their very nature, this issue of foreseeability that Senator Leach speaks of, by their very nature, ought to be a potential foreseeable consequence. So in each of those instances, force or the threat of force is a necessary element of the crime that you were helping someone commit. So this isn't a nonviolent offense that you helped someone commit. These are offenses that necessarily require some force or danger or inherent threat to human life. And as a result, once you sign up to help someone commit arson or robbery or rape, then you are recognizing the foreseeable consequence that, someone might be hurt, someone may even be killed as a part of your role there.
But I think what Senator Leach said was that you might not even know that's the crime they're going to commit, but they commit it. So do you need that? Do you need that kind of understanding or intent that this is the crime that's going to be committed, like the woman who went just to recover her stuff that she owned from someone's house?
Well, that was overturned.
Yeah,
we're talking about a case.
Not on the felony murder grounds. It was overturned on other grounds.
Okay.
So the issue, and I'd have to dig into the case law, but my understanding is you have to know that you are helping someone commit the underlying felony offense, the robbery, the rape, the involuntary deviant sexual intercourse. He's right that you might not know that someone's going to go ahead and pull the trigger when they go into the bank to rob it. But surely, if you're sitting outside, you drove them to the bank, and they go into the bank with a gun, it is a foreseeable potential consequence that someone is going to die or get seriously injured in that bank while you are in there with a gun with a mask over your face.
Do you have to know they have a gun?
Well, in the end, you don't in this particular, under Pennsylvania law, because the robbery in itself requires force or threat of force. Every one of these crimes requires some type of inherent danger to another human being. None of these are simply property crimes.
Burglary is a property crime that does not require force. Arson is also a property crime in most cases. Very few people commit intentional murder by arson. There's a couple of examples in history, but most people, the classic thing is, I'm going to burn down my restaurant for insurance money, or whatever it is. There's a lot of things that don't require force, and things, develop over time, but in a way that I have no responsibility for, because I would never have signed up for this, okay? And this goes to the idea, as I understand Todd's argument, but you signed up to do something wrong, okay? And that's true. But we have gotten away from this sort of bad person theory of punishment. Okay, that's why we don't allow, for example, if I'm being accused of a crime and I'm in trial and Todd's prosecuting me, he can't bring in most circumstances, previous bad acts I've done. This guy was convicted of shoplifting 8 years ago. He's a bad guy. We don't allow bad guy evidence, only for patterns, but we don't allow bad guy evidence at trial. And we don't punish people because they're bad people. We don't punish people like, he didn't actually kill anyone, or he didn't try to kill anyone, or he didn't want to kill anyone, but he's a bad guy. So let's punish him for killing someone, even though he didn't do that. Punish him for what he did. I'm all for that.
But that's not true, actually. In sentencing, all of that is relevant. You bring in the entire criminal history, you bring in everything about the individual, good and bad, at sentencing, to determine the punishment.
At sentencing.
Right.
But not guilt and innocence. I mean, once I'm convicted of second-degree murder, my sentencing options are limited.
Agreed.
Okay.
Agreed. There is another aspect of this, though, that I think is important to remember. In the case that I laid out, where we had, I think it was 7 total co-defendants, we moved forward for trial against 3 of them. The remainder of the players, in exchange for their cooperation to help us solve this case and convict these guys of murder, were given the opportunity to plead guilty to third-degree murder, and therefore came out from under that. So you always have the prosecutorial discretion involved, so that where you have the aberration that Senator Leach may be talking about, there is that safeguard there, but you're going to have to earn it. It's not the kind of thing where, look, I signed up to help you rape somebody and you decided to kill her, so now, you're just going to get off with a slap on the wrist. I mean, we're certainly not going to allow that.
You would get off with a rape conviction, accessory to rape, right? I mean, it wouldn't be a slap on the wrist. But I would say beyond that, and again, it's not between no punishment and life in prison. It's between life in prison for something you didn't do and punishment for what you did do, which I'm all for. But Todd talked about prosecutorial discretion. I have no doubt, and I've known Todd for a while, that he is a saint of a human being, that he deserves however many Nobel Peace Prizes he can get, okay? But you shouldn't have to rely on the prosecutor, because I did lots of criminal trials, okay? Not every prosecutor is like that. And you should not have to rely on the prosecutor being a nice guy or being a reasonable person or being in a good mood that day, or, you know, my life shouldn't be in the hands of a prosecutor. The law should protect me. And the prosecutor should be very limited at what they can do. Also the whole problem with the, you know, and Todd said, well, it helps us, we get cooperation out of people. I'm not a fan of overcharging or charging people with things they didn't do to force them to testify or to force them to plead guilty to some lesser crime. I mean, we give prosecutors so enormous power here. I mean, if you say to me, you know, if I'm somebody, and let's take an example of stealing the stereo speakers, okay? Now, you know, if I'm convicted of stealing stereo speakers, I'm going to serve, let's say, 4 years, whatever it is. And someone less honorable than Todd says, but we're going to put you in jail for life unless you do this, that, and the other thing. Well, what? Suddenly I have no choice in the matter. Like, I'm going to be doing things that I may not think are right because life in prison is such a draconian punishment. I mean, and so I just don't think we should give anyone the power to threaten people like that. I think the law should say, if you broke into a house, this is your punishment. And that's it. Not, we're going to punish you for something you didn't do unless you agree to do X, Y, and Z.
If you're signing up to help someone rape somebody else, you know going in, somebody's going to get hurt there. Now, there might be a question as to how seriously someone's going to get hurt, but there's no question someone's going to get hurt.
Okay.
And that's at the heart of why the felony murder doctrine exists, because that foreseeability is inherent in the types of offenses that we're talking about.
Todd said something very interesting about foreseeability. You know, I agree with the idea that if a crime is foreseeable, perhaps there should be punishment for the foreseeable conduct of the crime. What my reform says is, Todd has to prove foreseeability, because as he said, these are very fact-specific cases. In some cases, it wasn't foreseeable. But it's a presumption. It's not a presumption. It's strict liability under Pennsylvania law. There's a body, I'm guilty. Okay, Todd doesn't have to prove that it was foreseeable under the set of facts involved in that particular case. All my reform would say is, if you can prove that my conduct foreseeably led to a death, prove it. Take it to a jury, and the jury can decide that. I have no problem with that. I just don't want it to be an irrebuttable presumption or a strict liability situation where, whether it's foreseeable or not, we're going to assume it was.
So you're eliminating the strict liability, but if you can prove it was
My reform
foreseen,
essentially is one word. What it says, what the current law essentially says, I mean, it's a longer thing, but the key part of it says, if I am guilty of felony murder, if there was a homicide committed while I am an accomplice, okay, or a participant. I get rid of while and put by an accomplice, or committed by an accomplice, or thing, which makes it that I have to be involved in the murder in some way. And foreseeability is still part of that, you know, but prove that. This takes away any defense I would have that this is not foreseeable. Any defense based on the circumstances of the case.
Okay.
Well, and the reason for that is because the crimes, I mean, it's such a narrow list of crimes that they are de facto foreseeable in the eyes of those that passed the felony murder rule years ago, and in the eyes of folks like me who support it today.
But under particular fact situations, it may not be foreseeable, is what Senator Leach is arguing.
I can't envision a situation where a robbery doesn't have as a potential foreseeable consequence that someone is going to get hurt or killed.
But even if that's true, let's say I'm burglarizing your house and you're home. Todd would probably say it's foreseeable that you get hurt. But let's say some official,
It's foreseeable you might get hurt.
or some third party who wasn't even, some intermeddler who decides to start just shooting people because he sees lights he doesn't recognize. That's not really foreseeable from my perspective. Let's say you're not even the one that's hurt. Okay, let's say I'm a co-defendant is the one who hurt. In fact, some of the states have instituted a reform that said a co-member of the conspiracy cannot be. If they die, that cannot be the basis for invoking felony murder. Or if someone acts illegally. Let's say the cop comes and shoots someone illegally. Okay, excessive use of force. I can't predict and foresee excessive force. I shouldn't be responsible for that. The cop who did it should be responsible for that.
But here are the facts. When you sign up to help somebody commit a burglary. You're going to go into someone else's house. I mean, I don't think there's anyone who can say with a straight face that I couldn't possibly imagine the police showing up. I couldn't possibly imagine the homeowner, getting into an altercation with the person coming in the front door. I couldn't possibly imagine these things happening. I mean, the fact of the matter is, none of your viewers are going to say, my goodness, a guy walks into a bank with a mask over his face and a gun in his pocket, and he's going to rob the bank. I couldn't possibly imagine that someone got hurt.
But
think
of the legal standard he's advocating. I couldn't possibly imagine. I'm a business victim of domestic violence. I'm going to get my stuff out of someone's house. I couldn't possibly imagine that the boyfriend shows up. I couldn't possibly. I mean, once you get into that, I mean, we're supposed to make it very hard to put people in jail. Guilt beyond a reasonable doubt. It has to adhere very specifically to the statute. Being able to say, if you could possibly imagine some scenario, then you are guilty of murder if that scenario occurs, is a very low standard.
Take it to the higher standard. And find me the person who thinks that the guy walking into the bank with the mask over his face and the gun in his pocket, that, look, is somebody going to, is there a foreseeable chance that someone's going to get hurt in there or not?
How about the standard that we use in every other area of criminal law? Todd has to prove beyond a reasonable doubt that I knew that was going to happen or foresaw that was going to happen.
We like the idea, in the prosecutor's world, we often use the phrase, it's the three musketeers, all for one and one for all. And that applies all over the place, in the criminal world and outside the criminal world. There's teams of folks in here today. You have people operating soundboards, people operating cameras, you have a host, you have guests. Everybody has their role. You know what? If the young lady who's operating the soundboard weren't here, this show wouldn't go on, would it? Without the cameraman, the show wouldn't go on.
Yes,
Without
but
you, the
if
show
I
wouldn't go
libel
on.
somebody on this broadcast, they're not responsible.
Sure, I understand.
There is no felony fraud doctrine. There is no felony, burglary doctrine. There's no other area of the law where we just say that if you have any involvement in any aspect, you are guilty of the highest penalty. That's why some people
if you're
are
an accomplice, then you are guilty.
No, but you have to be
robbery.
you have to be an accomplice to the actual thing that you intended. If I intended to burglarize someone's house and someone else raped, we went in the house, we raped the person there. I'm not guilty of rape as an accomplice. There's no felony rape doctrine. It's only this one area of law. And the reason that doctrine doesn't exist anywhere else in the law is because it doesn't make any sense to punish me for rape if I didn't rape anybody.
Okay, I think you both made your point. You're just going back and forth with different examples. Thank you, Senator Leach and Representative Stevens, for being with us for this discussion.
Thank you.
It was awesome.
From the Winding River Production Studio, thanks to all of you for joining us for this episode of Reasoned Discourse with Jules Mermelstein.